Welcome to Audit the Court, where we break down the legal battles unfolding in courtrooms. Today, we step into Harris County Criminal Court in Houston, Texas, where Judge David Fletcher is known for challenging weak evidence and forcing the state to meet its constitutional duties. In this episode, part of our series on how probable cause is judged, he reviews whether the law justified charges against 4 defendants. Our first case begins with Ricardo Corral, charged on October 19, 2024, with assaulting his girlfriend under Texas Penal Code 22.01A1, which requires proof of bodily injury as defined in Section 1.07A8. According to Deputy G. Brent's affidavit, the girlfriend claimed Corral squeezed her arms during arguments and pulled her hair, and Brent noted bruising and that she cried while explaining what happened. Yet she also said she didn't feel pain at the time, though Brent insisted his training suggested bruises mean pain. Attorney James Pawns was assigned to Corral, and his arraignment was set for January 24, 2025.
That's why I'm up here, challenging the PC David on the complaint. He states that she stated she didn't feel any pain because she was fighting him as well.
But you said that you did feel pain.
But it's full to complete dim.
I wouldn't, or that's the problem, is the DIMS is maybe contradicting or inaccurate or different from the affidavit that I'm talking about, that the officer filed with the complaint.
So the complete DIMS reads, the complainant stated she did not feel pain at the time of the incident since she was fighting the defendant off of her, and that the officer observed the complainant shaking and crying, and the officer said, due to his training experience, I know being grabbed and bruises being left on her body causes pain. So according to the full DIMS, the complainant didn't say she felt pain. She said that she didn't feel pain at the time of the incident because she was fighting the defendant off of her. And that's what the full DIMS states. And the officer, based on training experience, saw the bruises on her and being grabbed and squeezed and came to the conclusion that it caused pain.
It could also be the exact, that what she said was, I was shaking and crying because I was fighting him. She's the one that says that.
I mean, I get it. Like at the time, you're in the stress of the excitement, so you're not feeling it. But then after.
That's not what she said, though, or that's not what
stress
going on.
Your Honor, the key thing the officer observed were the bruises on the complainant's arm. He observed the bruising and then came to the conclusion based on that. And what she told him, she did say that the defendant squeezed her arm. And based on that, her crying, shaking, and the bruising, he came to the conclusion that she felt pain due to that being squeezed.
I mean, taken as a totality, is that not sufficient for probable cause purposes?
I don't know. You have a sworn document where she says one of the elements is missing, and then everything else that he's adding is not in that document.
To be more specific, she's saying she did not feel pain at the time of the incident since you were fighting. She didn't say she didn't ever feel pain. She said at the time since she was fighting the defendant off of her.
But the officer
That's not in that.
But the officer never asked, hey, do you feel pain? Why
And
wouldn't you
because the officer
ask?
never asked, he came to the conclusion based on totality.
Get it, but I don't know. I mean, I need to look up case law. I'm not sure. I don't know if that's enough because I mean, it's such a low standard for probable cause purposes, you know? I mean, I get that you're saying that it's not alleged the pain as an element, but taken as a totality.
I guess you're saying taking as a totality. I'm saying that's a lot of speculation about stuff that's not in the DIMS or in the affidavit. Like you're making all these connections state.
I'm making the officer made the connection. He said in the DIMS, due to my training experience, I know being grabbed and bruises being left on your body causes pain. So
Right.
he made that connection.
You don't operate on hunches.
Right, and she's also stated that I was fighting him, so that could be because of her fighting.
I mean, here's the deal. Like if I find no PC, right, they may just re-indict it though.
That's fine.
You know?
That's their.
Kelsey,
Yes, sir.
did you see what's going on? So in this case here, the officer never asks her, do you feel pain? He assumes she does just because of bruising on her arm. And because I guess they're in the stress of the excitement. So at the time she doesn't feel pain, but after a while he assumes that she feels pain because of bruising on her arm.
And on body-worn camera, he never says, we don't know.
But I mean, this is a probable cause hearing. We haven't seen it. So he wants me to find no PC. If I do though, right.
Well, if there are visible injuries, we can go from there.
But he's saying that, I mean, if it were like blood, like some kind of tearing of the skin, that's one thing. But bruising, is it possible to get a bruise without feeling pain?
Yeah, I do
You
it
know?
all the time. If you fall downstairs and you're embarrassed more than in pain, you might be crying or shaking because you're embarrassed or excited, but it's not because of you injuring yourself down the stairs.
But Your Honor, that also ignores that she did say the squeeze itself. He mentioning a fall, but in this case, we do have a specific statement about a squeeze.
She doesn't say that she's in pain because of the squeeze.
So if we play it out in front of a jury, you would always have that statement saying at the time she didn't feel pain. Whatever you said contradicting that, that's fine, but it would not take away that statement that eliminates an element.
That's my son.
So maybe a grand jury might find it different, but based on that DIMS, they have someone saying, I didn't feel pain. I think that's kind of like,
And Your Honor, I will say at the time, we don't have the full OR, so if you want to find no PC, we can revisit it, and if we want to re-indict it, we can.
Okay, all right.
Argued that probable cause for the bodily injury element was missing because Corral's girlfriend clearly stated she felt no physical pain, and nothing beyond the deputy's assumptions suggested otherwise. Judge Fleer agreed and ruled that probable cause was lacking, leading the state to dismiss the case on February 5th, 2025. The next case involved Jananisha Winbush, charged on September 26, 2024, with interfering with a public servant under Section 38.15 of the Texas Penal Code, which bars interrupting, disrupting, impeding, or otherwise obstructing a public servant performing lawful duties. The law also specifies that a person cannot be prosecuted if their alleged interference consisted solely of speech. A probable cause hearing for Ms. Winbush took place on October 3rd, 2024, in Judge Flesh's courtroom.
Servant, you're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
On September 26, 2024, at approximately 1:15 p.m., an officer responded to a call at the TSU Library Center located at 3100 Claiborne Street in Harris County, Texas, regarding a disturbance. The officer made contact with the individual causing the disturbance, and the defendant approached asking officers what's going on and what did she do. The officers repeatedly asked the defendant to step back, and she became belligerent, asserting that they were at her store. She eventually complied and moved away, but she insisted that a police supervisor be called to the scene. TSU Sergeant Barnett arrived and spoke privately with the defendant. Afterwards, responding officer requested the defendant's information to report her behavior to her supervisor in the university. The defendant refused to provide it and attempted to bypass the officer. When the officer asked her to identify herself again, the defendant declined and attempted to walk away. As the officer tried to detain her, she began to throw herself on the ground and yell, escalating the disturbance. Several officers issued verbal commands for her to comply. The defendant continued to resist, jumping around and asserting her rights. The officer attempted to escort her outside. The defendant then wrapped her arms and legs around a pole, continuing to yell. The officers physically pried her from the pole and detained her. The defendant used her body weight to resist and push against the officers. The defendant was then placed in the back of the patrol car without incident.
What was she doing wrong?
So it appears she wasn't the initial person causing the disturbance, but when they came to respond to the disturbance that they were called for, she intervened. And once they asked her to remove herself from the situation, she refused.
You didn't say, when you initially started saying about everything, you didn't say that she was the initial cause of the disturbance, that there was a call for a disturbance. They get out there and she, I guess.
So what it says is that they made contact with the individual that was causing the disturbance, and then the defendant approached asking.
See,
the officer.
right. So she just comes up, starts being nosy, right?
Right.
And then she basically, I guess, is trying to leave. And then they start asking her for her information.
Well, they were asking her to leave the scene so that they can respond to the disturbance, and she wouldn't comply. I think that's the issue, that she wouldn't leave when
Did
they asked her.
you say that?
Yes. They asked her to move away from the scene and she refused to comply.
Show me, will you read that part again?
So when she approached the officers repeatedly asked the defendant to step back, and the defendant became belligerent, asserting that they were at her store. She eventually complied and moved away, but
So she complies, she moves away,
right. But then she came back.
okay?
And so at that point, when she returned, they asked her to identify herself. She refused to provide her identification. And then at that point, when they asked her to identify herself, she attempted to bypass the officers.
She leaves, she's trying to leave.
She is attempting to,
She's leaving.
attempting to leave again.
And then they start bucking up to her.
Sure, yeah.
Judge, what is this case?
It's on for tomorrow's docket. Let me give you the cause number. 251-1137.
Sounds like an interference. So
That's what she's charged with. But, so, sounds like she's got a case of the nosies, you know? She goes up there allegedly being nosy, she leaves, comes back, and then they start asking for her information. And she declines to give her information.
So Judge, what I'm looking at here, just to add context to the situation, she approaches in an unrelated incident, it looks like. She's asking what's going on. Fine. They talk to her individually. Okay. They tell her to leave. She continually asks what's going on. What did she do? She asserts, she becomes belligerent, is what the officer says, asserting that they were at her store, obstructing their investigation. Eventually, I don't know what the time frame is, but they say eventually she complies, moves away, but insisted that they need to call a supervisor to the area. A sergeant then spoke with her privately. After they responded and they requested her information to report her behavior to her supervisor at the university, and to identify her, which she refused to do. She then attempts to bypass officers. They ask her for identification again. They're detaining her. She says no.
But what's the interference? What did she specifically do?
Well,
She's just talking to them.
I understand,
Right?
Judge. She's talking to them, but she's saying that they're at her store. She's belligerent, telling them to leave. They're at her store. The position of the state judge is that did obstruct their investigation. I mean, it's not in this. There's multiple senses of obstruction, in our opinion. It's not.
Are you losing right now? Okay.
After reviewing the allegations against Ms. Windbush, Judge Fleer determined her behaviour did not rise to the level of interference with a public duty and found no probable cause, prompting the state to dismiss the case the same day. The next probable cause decision we're examining also involves interference with a public servant. Defendant Wah Wee Kemp was charged on January 26, 2025, for allegedly grabbing the arm of an EMS responder who was transporting his mother, who was suffering a medical emergency, to the hospital. Attorney Carolyn Okorafor was appointed to represent Kemp, and the probable cause hearing took place in Judge Fleer's courtroom on February 6, 2025.